This case is a textbook example of how a completely legal activity can spiral into a six-figure liability for a police force in under 10 minutes. What starts as a man lawfully flying a drone turns into confusion, escalating authority, and officers relying on powers they clearly don't understand. You'll hear claims about airspace ownership, stop-and-search powers being stretched beyond recognition, and threats of arrest that simply don't exist in law. The real tension here isn't just the confrontation, it's watching trained officers double down instead of reassess. So as you watch this unfold, ask yourself, at what point does enforcing the law turn into breaking it?
Just when I'm recording, my body warm's on. Is everything okay?
Yeah, I'm actually in control of an aircraft at the minute, so don't distract me.
No, I'm not distracting you. I just want to speak to you if everything's alright. You just got an aircraft with a camera, I presume, and you're flying over a police station. Is there any reason for that, pal?
Lots of reasons for everything, isn't there?
Yeah, there's a reason for absolutely everything, hence why I'm asking you.
You're distracting me, that's what you're doing.
I might be distracting you, but I just need to speak to you, pal.
You can wait, can't you? Or wait till I land it.
Absolutely, yeah, go ahead.
I'm not landing it right now.
What exactly are you trying to record, pal?
I'm just flying at the minute, mate.
For the moment, the reason as to why I'm coming to speak to you, do you want me to tell you?
To distract me?
No, negative, that's, well, if
you're distracting me now, so if I crash it into a car, it's your fault.
If I'm distracting you, that's just something that's occurred.
Something that's occurred. I've told you I'm in charge of an aircraft.
Why I'm trying to speak to
the reason why I'm telling you is because you're distracting me, and if I crash...
This moment is far more serious than it looks on first watch. Any officer interacting with a drone pilot should understand one basic rule: distraction mid-flight creates risk. Civil aviation safety guidance is clear: the pilot in command must not be interfered with. Instead of stepping back, the officer escalates, effectively creating the very danger he claims to be concerned about. And here's the legal kicker: if that drone had crashed and injured someone, the liability wouldn't fall neatly on the pilot alone. This is where poor decision-making starts opening the door to civil claims. Would you trust an officer who ignores basic safety principles like this?
For what? So, I'm not speaking to you at the minute, I'm flying an aircraft.
Do you want to land that down first, pal?
No.
Right, it's becoming a security issue now. I'm going to have to just put you in handcuffs first.
Right, can I land it first?
Do you mind landing it then? Yeah? I can put you in handcuffs down and I have to stop searching, pal.
Alright.
That's how it is. Do you want to land it now, or do you want to...
Can I land it now?
Go on then.
So you're detaining me?
Yes, at the moment I want to put you in handcuffs.
Under what section?
Section 1 of place, pal.
Alright.
So do you mind just...
Can I land it?
Yeah, absolutely. You have to move, do you?
Yeah, because I have to make sure it lands safely.
That's fine.
So,
do you want to put that down in your backpack, something like that, at least it's out of the way so you don't need to worry about it?
So why are you detaining me?
Section 1 stop search, pal.
Section 1, so you think I'm coming equipped to steal?
Negative, that's not remotely close.
Oh, that's Section 1 of PACE, isn't it?
Section 1 of PACE, yeah?
Yeah, is that what you do?
Section 1 of PACE is a stop search power, yeah?
Yeah, for what? For what reason?
If you like to put your hands away.
This is where the legal framework completely collapses. Section 1 of PACE is not a general power to stop someone because an officer feels uncomfortable. It requires specific objective grounds to suspect stolen goods or tools for theft, not curiosity, not vague intelligence, and certainly not a drone. When the officer admits he doesn't suspect theft, the detention instantly becomes unlawful. Courts don't treat this as a minor error. They treat it as a fundamental misuse of power. So here's the question for viewers. If officers don't understand when they can lawfully detain someone, how can the public ever feel secure exercising their rights?
Marked cars and playing cloned cars with fake number plates. If you want, you can like put that down.
No, it's alright.
That's fine, cool, pot noise. So that's one of the reasons as to why you're going to be detained. And now I can see you. I'm speaking to you. You're not giving me any reason as to why you're here at this very moment.
I don't have to account for being in a public place.
Absolutely not. You're not in a public place, but your drone is well within police property.
What, the airspace?
Yeah.
You do control the airspace, do you?
I'm not saying I control the airspace.
Well, you don't control the airspace. As you can see,
we've got recent intel claiming people are following police officers home in unmarked cars. I can't see that there's a car at the moment. I can't see any plane cars or the vehicle that I
So you've got no reasonable grounds then, have you?
I just explained my reasonable grounds.
No, they're not reasonable in my opinion.
My collar number's on my shoulder, pal. So if
I can't see it because of your collar.
You can see it right there, pal. My collar number's right there. If you've got any issues with anything that I'm doing today,
everything.
You know,
This exchange exposes one of the most persistent myths in policing, that owning land means controlling the airspace above it. That simply isn't true. In the UK, airspace is governed nationally, not by local police stations. The individual on the ground is standing in a public place, which is the only thing that matters here. Once the officer admits he hasn't actually observed suspicious behavior, his so-called intel loses all legal weight. Suspicion must be real, specific, and contemporaneous, not hypothetical. When that standard isn't met, lawsuits aren't just possible, they're predictable.
Years.
Yeah, you should know better than
I still have a couple of things I need to say to you. She just interrupted me. The reason...
You're not searching me then?
The ground... I am searching you. I'm just looking at it so it doesn't hurt your wrists.
Alright, but you're unlocking it.
No, I've seen it. I'm looking after you, if anything.
Well, you're not looking after my eye, you put me in handcuffs.
That's for your safety and my safety, you know how it is. The objects of my search is anything that could be used to follow police officers home, or any sort of anything that could be used in illegal means. Do you understand what I mean?
No.
Right, so essentially I'm looking for items.
So a car would be to follow...
Absolutely, so I'm looking for car keys for this certain car that I'm looking for.
What car are you looking for?
At the moment...
you don't know, do you? You're making it up. You're making it up as you go.
Not, absolutely.
Tell me what car it is then.
Absolutely.
Tell me what car it is then.
Personal information.
Oh, what an idiot.
Police safety and awareness.
Idiot.
So I can't really tell you
Idiot.
That's fine.
Oh, look at this now, idiots.
Yeah.
No, I'm not, mate. No, I'm not.
This is the exact moment courts zero in on during civil claims. Searching for car keys linked to a vehicle that the officer cannot identify isn't policing, it's improvisation under pressure. Reasonable suspicion must exist before a search begins, not be invented while handcuffs are already on. Judges consistently describe this as post hoc justification, and it's one of the fastest ways for a case to collapse. Watch how the explanations keep shifting. That inconsistency alone is devastating in court. Be honest, at this point, do you think the officer even knows what he's searching for?
He's doing it.
Come over here.
No,
Come over here. Come over here now. I'll get your equipment. Come over here now. Listen to me now. My colleague's not already explained this to you. You're now detained under Section 1 of PACE, which is the Police and Criminal Evidence Act 1984. The reasons for this are, I've got reason to suspect you're in the commission of offence by committing hostile reconnaissance in an area that's not open to the public. Right. You are going far beyond YouTubing for a YouTube video.
Really?
You are flying an unmanned aircraft without authorisation over a police station.
Don't need authorisation.
Pull that down.
No, that's illegal. Straight away.
It's not illegal.
It's really not
so
illegal.
I've got reasonable grounds to believe.
No.
I need to know.
This is for religious purposes.
It's not religious, is it?
Yeah, it is.
You want to get a reaction for whatever YouTube video you're doing, so this is what's going to happen. My colleague's going to put your handcuffs behind your back, and you're going to get stop searched. Once that's done, let's get your details. If I don't find anything in that bag on the grounds of the search and the stop search that we do, anything that prohibited items or illegal in the commission.
When the second officer arrives, this was the moment to de-escalate and correct course, and instead the opposite happens. Claims about needing permission from a chief constable or counsel to fly a drone are legally incorrect. Asserting authority without legal grounding doesn't strengthen a case, it compounds liability. Even more concerning is the interference with face coverings without lawful justification, which raises human rights issues. From this point forward, the encounter stops being about safety and becomes about control. Every additional step taken here increases the eventual settlement value. Would you have expected a senior officer to stop this or defend it?
The public
Didn't go in.
alarm. I'm not saying you did, but you flew your drone over the police station.
Which isn't illegal.
Let me explain to you now. You need authority to be flying an unmanned aircraft like that over 120 metres high in the sky, which is 400 feet.
I didn't go over 120 metres.
Well, we need to ascertain that.
Yeah,
so what's going to happen now is you're going to give my colleague your details in a minute. We're going to stop search you under Section 1 of PACE 1984. Once that's done, we'll P&C you, find out who you are, and what I suggest you do is you really think on about the behaviour you're committing. I get there's people like auditors, I get there's people that are interested in police stations, but you have not got permission off the Chief Constable of Greater Manchester Police or the Council to be filming this police station intrusively in an area that's clearly not open to the public. So at the moment, you're being detained for a stop search. Once that's been done...
Invoking Section 50 of the Police Reform Act here signals desperation. That power exists to address harassment, alarm, or distress caused to the public, not officers who are frustrated by lawful challenges. The irony is that the officers themselves created the confrontation by escalating a lawful encounter. Courts are absolutely clear. Police cannot provoke a situation and then criminalize the reaction. This misuse of Section 50 is precisely why forces settle rather than defend these cases in court. If accountability matters, this is where it failed most visibly.
That's why this case never stood a chance in court.
Let me explain to you now. You do, because let me explain something to you now. If you do not, under Section 50 of the Police Reform Act, I'm going to arrest you, take you to police custody, and live scan your fingerprints, get your photographs and DNA to find out who you are. Because you've caused several members of staff in here. Let me explain. Let me finish speaking. Listen, you've gone a level beyond filming the front of the gate of the police station. You've flown the drone around the police station, and my colleague saw you doing it from a top window in this building. This colleague stood here. For that reason, I can be satisfied now that you've gone beyond the level of causing harassment, alarm and distress to colleagues in here. So you give me those details. If you don't, that's fine. We'll take you to police custody and we'll find out who you are there.
On one condition.
It's not under condition. That's what's going to happen.
I want my phone recording you saying that, that I have to.
No, we've got body cam.
No, because I'll never get hold of that.
Yeah, you can.
No, I've tried it before. I don't get it.
Well, ultimately, mate, listen to me now. You've got 5 to 10 seconds to make a decision. If you don't, I'm going to take you to police custody. Following the search we're going to carry out under Section 1 of PACE 1984.
Right, search me first, then.
This case is a perfect example of how unlawful stops turn into
This case ends exactly where the law said it would. An unlawful detention, an invalid stop and search, fabricated grounds, and repeated misuse of police powers made this lawsuit unwinnable from the start. The settlement wasn't generosity, it was damage control. More importantly, this case reinforces a critical principle. Lawful behavior does not become illegal just because it makes authorities uncomfortable. Rights apply consistently, even when challenged.